Good morning. My name is Bruce Provan. I'm the Managing Director of Page Provan Family and Fertility Lawyers. We're a firm of lawyers in central Brisbane that practices exclusively in family and fertility law. I want to talk today about relocation cases. And now what a relocation case is where a parent intends or has already moved with a child to another location with the effect that the other parent is going to have less time or less contact with the child. So a relocation can, for example, be where a mother takes a child interstate or overseas so that the father is having less contact with the child. It's not a special category of cases under the Family Law Act. Under the Family Law Act, relocation cases are treated like other parenting cases where the court has to make a decision about what's in the best interests of the child. But these sorts of relocation cases are quite common, where one parent decides for whatever reason that they want to move with their child to another country, another state, or even sometimes within the state, sometimes it's to another side of the city. And I've heard judges say that these are the hardest cases they have to decide sometimes because you have the competing proposals of two good parents, and it's up to the judge to decide which of those proposals is in the best interests of the children. So there are cases where one parent moves with the child to another location without the consent of the other parent. We call that unilateral relocation. And there's nothing illegal about that, but what the court will often do in those cases is bring the matter on quickly, and they will often order the parent who has removed the child to go back to the town or city where they were living so that the child can continue to have a meaningful relationship and spend time with the other parent. But not in all cases. We see many cases where a parent, usually the mother, relocates with the child, but the court doesn't order the child to go back, at least not immediately. And that's especially in cases where there are allegations of domestic violence. The court would be loath to order the mother to go back to the original location with the child if there's a possibility that either she or the child or both may be subjected to further domestic violence. So in each case, it's up to the discretion of the particular judge. Now, often in these sorts of relocation cases, the matter will come on for an interim or temporary hearing where the judge has got to decide what they're going to do or what order they will make regarding the child pending a final hearing. Now, there's an important distinction between the two because at an interim hearing, there is no cross-examination allowed. There is usually not a family report. And so at an interim hearing, all the judge can go on is the affidavits, court documents filed by the parties, as well as the submissions that might be made by their lawyers. Whereas at a final hearing, there will be a much greater detail. There will be cross-examination of the parties, there will be reports, there will usually be a family report, and there might be an independent children's lawyer appointed to represent their children. And at that stage, the judge can give determination as to what the final arrangements are going to be. So in deciding a relocation case, what the paramount consideration is the best interests of the child, and there's a number of criteria set out in the Family Law Act for the court to make a decision about what's in the best interests of the child. Obviously, no two cases are the same, and as lawyers, for that reason, it's hard to give advice. The principles are similar whether the relocation is going to be interstate, overseas, or even, as I mentioned, sometimes even within the same city. In other words, going back to what's in the best interests of the child. Now, for a parent who wants to relocate, there's no requirement for them to establish compelling reasons to move. The reasons parents commonly want to move with their child is if they have family who are interstate, if they have a new partner, or there's employment opportunities interstate that cause them to want to move. Now, there's nothing to stop a parent from moving with a child. Parents are allowed to live wherever they like. The court's only jurisdiction is to make an order about where the children live, and the courts can make orders about where the child lives, who the child lives with. A court, for example, may order a child to return to the original town or city of residence, and the other parent may decide that they're not going to move back with the child, although that is rare. The court can also make orders about how much time the child spends with each of the parents, what communication is going to be involved, etc. So, in weighing up what's in the best interests of the children, the judge has regard to a number of factors, and often their decision is based to some extent upon the reports that are provided to them. I mentioned earlier, commonly in these cases, a family report would be prepared, usually by a psychologist or social worker who would interview the parties, the children, possibly other people as well, and make a report to the court. And that's only one of a number of factors that the judge has to take into account in making their decision. So, the types of factors that a judge would consider is first the reasons for the move, and although the person who wants to relocate is not required to show compelling reasons, their reasons for relocating is something that a judge would have to take into account. The other thing is the effect on the child. For example, for a child to relocate would mean a change of not only home, a change of school, and what impact is that going to have upon the child. Another factor the court has to take into account is the genuineness and detail of the proposed move. So a parent proposing to relocate would usually have to give fairly specific detail to the court about where they want to move to, when they want to move, why they want to move, where the children would go to school, and what proposal they have for the child to have contact with the other parent if they're allowed to relocate. And that's one of the key things that the judge has to take into account is, look, if I allow this parent to relocate with the child, how much time is the child going to be able to spend with the other parent, and how are they going to be able to communicate with the other parent? So, for example, if a child has had a lot of contact with the other parent, and this is usually the father, it's going to be harder to persuade a court that a child should be able to relocate, whereas a child who only has sporadic or inconsistent contact with the father, it's probably an easier task to persuade the court that the child should relocate. The other thing the court needs to take into account is the practicality. So, for example, a parent wanting to relocate to another city would need to make not only proposals but also set out, for example, if relocation is allowed, how often the child could fly back to see the other parent in the other city, or that the other parent could go and visit the child, for example, on weekends and for school holidays. Another factor that the court has to take into account is whether there's a possibility that the other parent could possibly relocate to the city or town where the original parent wants to relocate with the child. One of the key matters that the court has to take into account is the mental health of the parent. In a case of MRR and GR, which is a case decided about 10 or 15 years ago, a couple from Sydney moved to Mount Isa, and there were children born in Mount Isa, and when the couple separated, the mother took the children back to Sydney where she was from because she had family support. The husband then made an application to court to require the mother to relocate to Mount Isa, where he was working as an engineer. And in that case, the court, in the first single judge decision, ordered that the mother was to relocate to Mount Isa so that the father could spend equal time with the child in a week about arrangement. The mother then appealed to the full court of the family court, who said that the trial judge got it right and that the mother should be required to stay in Mount Isa. From there, the mother got leave to appeal to the High Court, and in the High Court said that the court needs to take into account the whole circumstances regarding the health and welfare not only of the child but of the parents. And in that situation, the mother was back living in Mount Isa, had been there for some time by this stage. Her mental health was starting to deteriorate. She was living in a caravan park, and the High Court decided that it was in the best interest of the child to allow the mother to relocate to Sydney with the child. So for a parent intending to relocate, they really should get advice from a lawyer at an early stage. If they've already moved a unilateral relocation, they should obtain advice immediately, because there's a good chance that the matter will end up in court pretty quickly and will need representation if she wants to defend an application to require them to relocate with the child back to the original location. My name is Bruce Provan. I'm the Managing Director of Page Provan Family and Fertility Lawyers.